Hello, prudent viewers. Today we're discussing a topic that many prefer to postpone, but that is absolutely crucial for peace of mind and family harmony. Essential legal documents for seniors. Having the right paperwork in place isn't about surrendering control or dwelling on difficult scenarios. It's about ensuring your wishes are honored, protecting your assets, and sparing your loved ones from unnecessary stress during challenging times. Unfortunately, many families discover too late the complications that arise when these documents aren't prepared. Today, we'll explore the 5 essential legal documents every senior should have. We'll explain what each document does, why it's important, and basic steps to get them in order. This isn't legal advice, but a roadmap to help you prepare for important conversations with legal professionals. Let's get started with this crucial aspect of life planning. Document 1. Durable Power of Attorney for Finances. This document authorizes someone you trust to manage your financial affairs if you become unable to do so. Why it's essential. It allows bills to be paid and financial matters handled even if you're incapacitated. Prevents the need for court-appointed guardianship, which is often costly and time-consuming. Ensures someone you trust, not the courts, is making your financial decisions. Can be customized to grant limited or broad powers. Takes effect either immediately or only upon incapacity, depending on how it's written. Key considerations. Choose your agent and alternates carefully. They should be trustworthy, financially responsible, and willing to serve. Be specific about what powers you're granting, such as banking, real estate, investments, or taxes. Consider requiring your agent to provide regular accounting to another family member. Update this document periodically, especially after major life changes. Ensure that financial institutions will accept your POA. Some require their own forms. Without this document, if you become incapacitated without a POA, your family may need to petition the court for guardianship, a public, expensive, and potentially stressful process. Document 2, Advanced Healthcare Directive. This is a 2-part document. It includes a living will and a healthcare power of attorney. It outlines your medical wishes and appoints someone to make decisions if you cannot. Why it's essential. Ensures medical treatment aligns with your values and preferences. Relieves family members from making difficult decisions without guidance. Prevents potential disagreements among loved ones. Provides clear instructions about your end-of-life care preferences. Gives your doctors a clear understanding of your wishes. Key components. The living will specifies what treatments you would or wouldn't want, such as ventilators, feeding tubes, or resuscitation. The healthcare power of attorney names your healthcare agent and alternates to make decisions on your behalf. Key considerations. Choose someone who understands your values and will advocate for your wishes, even if they differ from their own. Discuss your wishes with your agent well before a crisis occurs. Make copies available to your doctor, your hospital, your agent, and close family members. Review and update regularly, especially after any major health changes. If you have a serious illness, consider adding a post form, physician orders for life-sustaining treatment, for immediate medical orders. Without this document, decisions may be made that don't reflect your wishes. Family members may disagree, adding stress during already difficult times. Document 3, Last Will and Testament. This document directs how your assets should be distributed after your death and can name guardians for dependents. Why it's essential. Ensures your assets go to your chosen beneficiaries. Names an executor to manage the process. Can designate guardians for dependents. Can include specific instructions for sentimental items. Prevents your estate from being divided according to state intestacy laws. Key considerations. Choose an executor who is organized, trustworthy, and preferably younger than you. Be specific when distributing sentimental belongings to prevent conflict. Consider explaining your decisions to your family to avoid confusion or resentment. Update your will after major life events, such as births, deaths, marriages, or divorces. Ensure it's legally valid, according to your state's rules with proper witnesses or notarization. Store it in a secure but accessible location, and tell your executor where to find it. Without this document, state law will determine who inherits your assets, which may not align with your wishes. The probate process may be longer, more expensive, and more likely to result in conflict. Document 4. Revocable Living Trust. This legal arrangement holds your assets during your lifetime and outlines how they'll be managed and distributed after death. Why it's essential. Avoids probate, saving time and keeping your affairs private. Provides management of assets if you become incapacitated. May reduce estate taxes in certain cases. Allows for more detailed distribution like staged inheritances. Is less likely to be contested than a will. Key considerations. Assets must be titled in the name of the trust, or they'll still go through probate. You maintain control as the trustee during your lifetime. Name successor trustees to take over if you're unable. More complex and costly to set up than a will, but often worth it. Still requires a pour-over will to cover any assets not placed in the trust. Review and update regularly, especially after acquiring new assets. Without this document, your estate may go through probate, a public, potentially slow and expensive process. There may be less flexibility in distributing assets. Document 5. HIPAA Authorization Form. This form allows your healthcare providers to share medical information with the people you designate. Why it's essential. Allows trusted individuals to access your medical records and help coordinate care. Is separate from a healthcare POA, which only takes effect if you're incapacitated. Lets you authorize multiple people, such as children or siblings, especially important for unmarried partners who have no automatic rights. You can define exactly what information is shared and with whom. Key considerations. List everyone you want to have access. Update the list as relationships change. Provide copies to all of your healthcare providers. Clarify the scope. You can limit the type of information shared. This form does not give decision-making power, only access to information. Without this document, even close family members may be denied information about your condition. This can delay care, cause confusion, and make coordination difficult. Conclusion. These 5 essential documents, Durable Power of Attorney for Finances, Advanced Healthcare Directive, Last Will and Testament, Revocable Living Trust, and HIPAA Authorization, form the foundation of a sound estate plan. Having them in place is one of the greatest gifts you can give, both to yourself and to those you love. Creating these documents may feel overwhelming, but the peace of mind they provide is worth every effort. Consider working with an elder law attorney. Many offer affordable initial consultations. The investment is small compared to the protection and clarity these documents offer. Review your documents every few years or after any major life event. Store them in a secure but accessible place and make sure your agents know where to find them. By taking these steps now, you ensure your wishes will be respected and your loved ones spared unnecessary confusion and stress. Next week, we'll discuss 7 warning signs that it may be time to stop driving. Don't miss this important conversation. If you found this video helpful, give it a thumbs up and share it with someone who might benefit. Until next time, plan wisely for peace of mind.